Timeshare regulation builds on the same consumer protection framework you have seen throughout Arizona real estate law. Money that belongs to a buyer must be handled transparently, safeguarded from misuse, and traceable through records that can be audited by the Arizona Department of Real Estate. In timeshare transactions, that protection is strongest during the purchaser's rescission period because the law recognizes that the buyer has a legal right to change their mind and recover their funds without penalty when they cancel correctly under the contract and statute. Arizona requires a developer to treat funds received during this window as protected monies, not as income that can be spent or commingled. A developer of a timeshare plan must deposit 100% of all monies received during the purchaser's rescission period into an escrow or trust account in a federally insured depository. And that deposit must be supported by a written agreement between the developer and the escrow or trust account agent. The rule is simple in concept and strict in application. Funds collected during the rescission period must sit in escrow or a trust account until the rescission period ends, and disbursement is limited by law. The escrow or trust agreement must provide that funds may be dispersed to the developer only after the rescission period expires, and only in accordance with the purchase agreement, subject to additional protections when construction is not complete. If the purchaser cancels pursuant to the agreement's terms, the monies must be paid to the purchaser or paid to the developer only if the developer has already refunded the purchaser. This creates an important compliance pattern you should recognize from trust account rules in property management. The law cares less about who possesses money and more about whether the system guarantees the rightful party can get it back when the law requires. A practical example makes this easier. Imagine a buyer signs a timeshare purchase agreement on Monday and gives a deposit plus the first installment. During the rescission period, the developer cannot treat that money as earned revenue, cannot move it into an operating account, and cannot use it to pay marketing costs. The funds must remain protected in escrow or a trust account so that if the buyer cancels properly, the refund can be made without delay or dispute. This requirement also reduces consumer harm if the developer becomes insolvent or disappears, because the money is being held by an independent escrow or trust agent, rather than being spent by the seller. The escrow rules become even more protective when the purchaser buys a timeshare interest in a property where construction is not completed. Arizona law requires that even after the rescission period expires, the developer must continue to maintain in escrow or a trust account all monies received from the purchaser under the purchase agreement when the construction of the timeshare property has not been completed. This is a major concept for exam purposes. The end of rescission does not automatically mean release of funds when the buyer is purchasing into an incomplete project. The law keeps funds in a protected account because the buyer is exposed to completion risk, meaning the buyer could pay for an accommodation that is not yet safe, legal, or usable, and possibly no public report has been approved by the ADRE. Arizona also defines what evidence of completion may look like, because escrow release must be tied to objective proof, not a developer's promise. Acceptable evidence of completion includes items such as a certificate of occupancy, a certificate of substantial completion, an equivalent public safety inspection from the local jurisdiction, or other evidence acceptable to the commissioner or provided by rule. In other words, the law ties money release to construction reality, not marketing timelines. If a buyer's funds have not already been dispersed due to buyer default, the escrow agent may disperse monies to the developer upon issuance of acceptable evidence of completion of construction. The statute also anticipates the most common failure points in real estate transactions: cancellation, buyer default, and developer default. If the purchaser properly cancels under the agreement's terms, the monies must be paid to the purchaser or to the developer only if the developer already refunded the purchaser. If the purchaser defaults under the purchase agreement, the monies may be paid to the developer. If the developer defaults under the purchase agreement, the monies must be paid to the purchaser. This structure is designed to prevent a developer from holding buyer funds hostage during a dispute and to ensure there is a predictable, lawful path for the escrow agent to follow. Arizona adds one more layer of protection by allowing the commissioner, in limited circumstances, to accept a substitute for escrow. In lieu of placing monies in escrow, the commissioner may accept a surety bond, an irrevocable letter of credit, or other financial assurance acceptable to the commissioner or provided by rule, and the financial assurance must be in an amount equal to or exceeding what would otherwise be placed in escrow or equal to or exceeding the cost to complete the incomplete property. The testable idea is that the state is not simply trusting developers. It requires either protected funds in escrow or a financial backstop that protects purchasers if the project is not completed. Finally, the developer's compliance duties do not end once the account is opened. The developer must make documents related to the escrow or trust account available to the commissioner on request. If monies are disputed, the statute requires those disputed funds to remain in escrow until either all parties give written direction signed by everyone or a civil action is filed, in which case the developer must deposit the monies with the court of appropriate jurisdiction. This mirrors the broader real estate theme you have learned in agency, disclosure, and trust accounting. Disputes are handled through written consent or the courts, not through self-help by the party holding the money. Review summary. Arizona requires strong financial protections for timeshare purchasers because rescission rights and construction risk create a unique consumer vulnerability. 100% of monies received during the purchaser's rescission period must be deposited into an escrow or trust account in a federally insured depository and governed by an executed agreement with an escrow or trust account agent. Funds may be released to the developer only after the rescission period ends and as the purchase agreement permits, and cancellations must result in a refund path for the purchaser. When construction is not complete, monies must remain in escrow even after rescission expires until acceptable evidence of completion exists. And the statute outlines what documentation can prove completion and how funds are handled in cancellation or default situations. The commissioner may accept financial assurance in place of escrow under strict conditions. And escrow documentation must be available to the commissioner with disputed monies preserved until written direction or court action resolves the dispute. Discussion A. Purchaser signs a timeshare purchase agreement and delivers a deposit. Why does Arizona require 100% of those monies to be placed in escrow during the rescission period? Answer. Because the purchaser has a legal right to cancel during that period, and the escrow requirement ensures the money is protected and refundable, rather than spent or commingled by the developer. A timeshare interest is sold in a property that is not yet completed. Why does Arizona require continued escrow after the rescission period ends? Answer. Because construction risk remains after rescission, and the law protects the purchaser by holding funds until objective evidence shows the accommodation is completed and safe for lawful occupancy. What happens to disputed escrow monies if the parties cannot agree in writing on a release? Answer. The disputed monies remain in escrow until a civil action is filed, at which point the monies are deposited with the court of appropriate jurisdiction. Closing remarks. Timeshare, escrow, and trust account rules are a focused application of Arizona's broader consumer protection approach to real estate money handling. The state treats rescission period payments and incomplete construction payments as funds requiring heightened safeguards. For exam success, remember the sequence. Collect funds, protect them in escrow during rescission, extend protection when construction is incomplete, release only with lawful triggers, and preserve disputed monies until written consent or the courts resolve the dispute.